Judge, I just have one. It's State of Florida versus Joseph Duggar, case number 26-809 CFMA with Mr. Ferreira. Your Honor, the state did file an information. We previously filed a written plea of not guilty. So I would simply ask for a pretrial date. I know you signed an order this morning allowing the state to turn over some of the additional, I'll call it DCF. So we'll still need to get a hold of that before scheduling depositions.
We'll set it for July 14th at 9 o'clock and see where we're at.
Yes, Your Honor. Thank you, Judge. I appreciate it. Have a great day.
Have a motion on Wednesday? Did it get set for Wednesday, or are we hearing that motion?
What motion?
There's a motion to modify the contact and supervision. I don't know if a notice of hearing was filed to make it for Wednesday, or if we're going to argue that next month.
Your Honor, I have not filed a notice of hearing. Ms. Nelson did send an email to us last night mentioning that Wednesday afternoon is available. But in light of the fact that the state may need more time to contact family members, perhaps, I'm not sure. I don't object to doing it in June. There'll be another motion getting filed anyway, so that might work better to do it in June.
All right, let's just set it for July 14th at 9 o'clock. If their motions need to be set, we'll set them on that motion docket when you file a notice.
Okay. Thank you, Your Honor.
There is a moment in every criminal case where the defense reveals exactly how worried they really are. And Joseph Duggar's team just had that moment in a courtroom in Florida, and they may not even realize how much they gave away. Everything discussed here comes from public court records, verified news reporting, and official legal documents. That is the standard this channel holds itself to. Joseph Duggar, youngest brother of Josh Duggar, who was convicted on federal child sexual abuse material charges in 2021, is now facing his own criminal case in the state of Florida, a life felony, 2 counts. Filed under seal on March 19th, 2026, and here is where the story gets interesting. For weeks leading up to this moment, his legal team was publicly suggesting that no formal charges had even been filed, that the case lacked substance, that everything was still uncertain. Then his attorney walked into arraignment and referenced the state's information, the formal charging document, like it was routine paperwork. So which is it? The arraignment itself lasted less than 2 minutes. Joseph was not present. His attorney appeared remotely, entered a formal not guilty, and asked the court to schedule a pre-trial hearing. The judge set that date for July 14th. That was essentially the whole proceeding. But what happened around that 2-minute window tells a much bigger story. Before the arraignment, Joseph's legal team had filed a motion asking the court to modify the conditions of his release, specifically to allow him unsupervised contact, including, presumably, his own children. Now, under current Florida law, once a court establishes bond restrictions, those restrictions carry a legal presumption of necessity. The judge already determined that Joseph should have no unsupervised contact with minors. That determination stands unless the defense provides compelling new evidence to change it. That burden falls entirely on Joseph's team, not the prosecution. The defense has to walk into court and prove with evidence that circumstances have materially changed and that the original restrictions are no longer warranted. So, what evidence did they bring? Nothing yet. When the prosecutor asked about the motion, asked directly whether they were ready to argue it, Joseph's attorney deferred. He suggested the state might need. The judge did not show much interest in entertaining it before July. Here is the part that most people overlook. The timing of that motion matters enormously. According to the court record, the judge had recently signed an order compelling the state to turn over investigative materials to the defense. Joseph's team is now entitled to review portions of the investigation. That changes the landscape of the case significantly, but it does not change the bond restrictions. And here is the strategic problem his team created for themselves. They filed the motion for unsupervised contact before they had reviewed the evidence the state was about to hand them, which means they filed it without knowing what is in that. And once that evidence was moving toward them, once depositions became the priority, the motion quietly got shelved until July. Think about what that sequence communicates to the court. Because the charges Joseph is facing are not minor. A life felony in Florida carries a minimum sentence of 25 years, and that minimum comes attached to lifetime supervised release. The maximum is life in prison. If convicted, Joseph Duggar registers as a sex offender for life. No version of this outcome is a clean exit, and the judge assigned to this case has a documented record when it comes to crimes against children. Earlier this year, this same judge sentenced a Panama City man convicted of a sexual offense against a 10-year-old child to 2 consecutive life sentences, meaning the sentences run back, not simultaneously. No possibility of parole, no chance of release. In a separate case in February, the judge rejected defense requests for leniency based on personal hardship and denied a convicted defendant's request to embrace family members before being taken into custody. This is the judge now presiding over Joseph Duggar's case. There is something worth understanding about how Florida law approaches these charges. The severity classification is based on the age of the child and the intent of the accused, not the specific nature of the act. The law treats harm to a child as significant regardless of degree. That standard removes one of the most common defense strategies before it can even. So where does this leave Joseph Duggar right now? He has entered a not guilty plea. He has a legal team preparing to challenge the evidence through depositions of investigators. Notably, Florida's 2025 law change prohibits compelling minors under 16 to testify or sit for depositions, which limits the defense's direct access to certain witnesses. His team has signaled they will file and a request to be near his children has been quietly postponed to a date the judge did not appear eager to prioritize. The defense is not in a strong position right now. They cannot argue the case does not exist. The state just handed them the evidence that proves it does. They cannot argue the charges are informal. The information was filed March 19th. And they cannot argue Joseph poses no risk without a formal safety plan, third-party monitoring arrangements, and supporting affidavits, none of which appear to exist yet. What makes this particularly striking is that the defense's own actions are drawing the map. Every motion filed, deferred, or avoided tells the court something. And this judge appears to be paying attention. The next hearing is set for July 14th. By that point, the defense will have reviewed more of the investigation file. More motions are expected. The case will begin to take shape in ways that cannot be walked back. Joseph Duggar grew up in a world where consequences were managed internally, where accountability rarely reached outside the family, and where legal systems were treated as something to be navigated around. What is unfolding in Florida right now is a fundamentally different kind of reckoning. The evidence is moving. The judge is watching. And July 14th is closer than it looks.